My dear aspirants, let us take 10 more questions from our series and learn a little bit more about our country's system of governance. Here's the first question. When a court declares a legislation as ultra vires, which of the following is signified by the declaration? Now, ultravires describes any act or decision taken by an entity that exceeds their legal scope of their authority. It is simply about what they are allowed to do and not allowed to do. More like a competence. Are they having the competency to do it? First option says repugnancy with another legislation. Now, repugnancy is a direct clash between two competing laws, usually passed by different legislative bodies, like a central government versus a state government. For example, if both the state and the central governments in India have the right to pass laws on the subject of education, but their specific rules contradict each other, then the state law is struck down due to repugnancy, not because the state lacked the power to make education laws. Second option says lack of competence of the legislature concerned. Well, this is precisely the meaning of ultravires, but still, let us see the other options. Third says arbitrariness in the legislation. Now, see, arbitrariness focuses on how the power has been used, whereas ultravires focuses on if the power exists at all. For example, a government agency has the legal authority to set safety standards for vehicles. However, if they pass a rule banning red cars because the director dislikes the color, the rule is arbitrary and irrational, even though setting vehicle rules is within their power. And the picture on the screen is of retired Justice Nariman, who was a pioneer of non arbitrariness in the recent times by being a voice in the famous Shaira Bano case of triple talaq in 2017 and also the judgment regarding homosexuality in the Navtej Singh Johar case. Fourth option says malafides in the legislation. Now, an act can be intra vires, that is within a person's legal power, but can still be malafied. For example, president can remove the governor. If it is done to settle political scores by the central government, the act is malafied, though it is within the powers of the central government. So it would not be ultra vires, but yes, it will be malafides. So anyway, the correct answer is clearly B here. So move on to the next question where it talks about part 9A, which we know is about, panchayats of our constitution. And it is asking the Nagar Panchayat is for which kind of an area. Now, Nagar Panchayat is essentially Article 243Q of the Constitution. So, which envisages three types of urban local bodies. Let's have a look. 243Q, there are three types of local bodies here. A Nagar Panchayat for a transitional area, a municipal council for a smaller urban area, and a municipal corporation for a larger urban area. And it defines a Nagar Panchayat as a area in transition from a rural area to an urban area. That is an area in transition, from rural to urban. And who would decide this? Constitution states that it is the governor who may, make that decision by a public notification by having regard to the population of the area, the density of the population, the revenue generated by the local administration, the percentage of employment in non-agricultural activities, economic importance, and other such factors. So the correct answer here for the question is transitional area. And the next question relates to the borrowing by the governments. So first statement says the Union Executive can borrow upon the security of the Consolidated Fund of India. Now this is absolutely correct, and this is according to Article 292 of the Constitution. Similarly, second statement says the state government cannot directly borrow from foreign agencies. This is also correct, and this is as per Article 293 of the Constitution. Let us see both these provisions in the Constitution. So, Article 292 clearly states that the executive power of the Union extends to borrowing upon the security of the Consolidated Fund of India within the limits as fixed by the Parliament by law. Similarly, borrowing by the states, it says that the executive power of a state extends to borrowing within the territory of India, as may from time to time be fixed by the legislature of that state by making a law. Then the third Option says state government entities implementing some infrastructure projects can directly borrow from foreign agencies. Now, this is correct. However, the statement here is a very general statement. The reason I made it so general is to ensure that all of you have got this idea. So, this is according to a 2017 policy of the Union government. And just to show you that, it allows direct borrowing by financially sound state government entities from bilateral ODA, official development assistance partners, right? Based on the state government guarantee and government of India counter guarantee. So these kind of entities can borrow from foreign agencies, limited, bilateral partners only. Though there are also some conditions to qualify for this. For example, you see here it says that major infrastructure projects with estimated cost of 5,000 crores or more. Similarly, it says they should have regular revenue stream, right? So that the revenues to be generated from the project should be enough for repayment of principal amount and the interest. Similarly, it also says that average annual revenue of not less than 1,000 crores for the previous 3 years. Further, it says positive net worth for the last 3 years with an average annual profit or surplus of not less than rupees 500 crores in the last 3 years. You don't have to remember these kind of factual information. I don't think it's really that important, but have a sense of it that such entities, not the state government, but these entities can borrow. State government will have to give guarantee. Government of India will give a counter guarantee. Anyway, so the next question is regarding languages in India. And first statement says that it shall be the duty of the union to promote the spread of the Hindi language as per the constitution. Now, this is absolutely correct. In fact, this is very clearly written in Article 395 of the constitution. We can have a quick read also. It says it shall be the duty of the union to promote the spread of Hindi language, to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India. You can read the rest of it also on your own. Then it says a member of parliament may speak in the house in their own mother tongue. This is also correct. This is coming from Article 120. And just to show you that, it says while the business in the parliament shall be transacted in Hindi or English, the chairman or the speaker, they may permit any member who cannot adequately express himself in these two languages to address the house in the mother tongue. So it is totally possible. Of course, the presiding officer has to allow this. Then the third statement says a minister of the union, while giving a reply, shall speak either in English or Hindi. This is also correct because these two are the official languages of the union government. So the minister of the union has to give a reply only in one of these two languages. The next question is regarding the provisions which were repealed by the Constitution of India when it came to force, that is in 1950, 26th of January. This relates to Article 395 of the Constitution, and we can have a look there. It very clearly says that the Indian Independence Act 1947 and the Government of India Act 1935, together with all enactments amending or supplementing but not including the abolition of Privy Council Jurisdiction Act 1949 are repealed. So Indian Independence Act and Government of India Act, these two were repealed. Now this 1949 Act, Privy Council Jurisdiction, it officially abolished the jurisdiction of the Privy Councils which operated in the London, and it transferred the judicial powers to the Federal Court of India. However, it also permitted the pending appeals before the Privy Council to continue until they were disposed. So it was all the new cases, they will go to federal court. Pending cases before Privy Council, they will continue. So if this was also repealed in 1950, it would have instantly terminated the legal validity of all those ongoing proceedings with the Privy Council, and the litigants would have been stranded. So this was not repealed. Then the next question is offices that are not provided under the third schedule of the Constitution of India. Now, see, third schedule is the various forms of oath. And which oaths are there? Let's be very clear. For the union level, it says the parliament, the members of parliament, even the candidates of parliament, the members of parliament, and the ministers. And the ministers have two oaths, that is the oath of office and the oath of secrecy. So these four forms are there, and similarly, same things for the state also. So for the state legislature, the candidate of state legislature, the members of the state legislature, and the ministers of the state. That is again oath of office and oath of secrecy. Then it also has the judges of Supreme Court and the judges of High Court. And the form of oath of the judge of Supreme Court is also the form of oath of C and AG. So these are all the offices for which oath has been provided. The form has been provided. So the three options given to you, CEC, the UPSC, and the Attorney General of India, they are not provided, and that is why all of these are not provided. All three are the correct answer here. Then the next one says about the term gerrymandering. Now, sometimes it is called gerrymandering, but in the next question, we will see the background of this. So, yeah, gerrymandering or gerrymandering. First statement says a time wasting tactic used by legislators to make extremely long speeches to prevent a vote on a bill. Now, this is wrong. This is exactly what is called filibuster. If you remember watching the previous video from this, I had explained there with a simple picture what is the idea of filibuster. Second statement says the practice where members of two different groups in the legislature agree to support each other's proposals in the House. Now, this is also incorrect because this is the idea of log rolling. Uh, for these kind of terms like log rolling, filibuster, see the video of question 621 to 630. So this is also wrong. Third says manipulation of constituency boundaries to unfairly give advantage to a political party or group. Now this is correct. As I said, I will explain this in the next question in more detail. Then it says disproportionate and unequal representation of constituencies. Now, gerrymandering is not about disproportionality or inequality of representation. That may actually be proportional and equal also after gerrymandering. The issue is of designing the constituency geographically in such a way to gain advantage. So be clear about this. And in the previous slide, you saw the first chairman of Law Commission of India after independence. You must also know the first ever Law Commission's chairman, Thomas Babington Macaulay, remembered till today for multiple reasons. For his existence in India definitely had a long-lasting impact. Next question. It's again giving some statements about this idea of gerrymandering or gerrymandering. See, 19% could get it right. Another example of how we may know something, but only superficially. Previous question, if you recall, 67%, shows that 67% of those who attempted it on Telegram know what is gerrymandering as an idea, but details of it only 19%, as that needs some curiosity and systematic study, many times by self only. So first statement here, the term has originated in the United Kingdom. Now this is wrong. This has not originated in the United Kingdom. It originated in the United States. It was actually in 1812 that the governor of Massachusetts, Elbridge Gerry, okay, Elbridge Gerry, who also became the vice president of USA later, signed a bill that created a partisan district in the Boston area that was compared to the shape of a mythological salamander, which you can see here also in the background image. This mythical entity. This was the kind of design they made for this constituency. A district was created. So the term became notoriously popular by adding the governor's name and this mythical character as Jerry and mandering, the word from salamander, which over time is often spoken, now as gerrymandering, but it was actually Gary whose name was added there. Anyway, second statement says cracking is an example where voting power of the opposition is concentrated in one constituency. And it says packing can be a strategy to dilute the voting power of opposition supporters across different constituencies. Even if you see the literal idea, which cracking means to break apart. Packing is to put lot of things in one place. The definitions have been interchanged. So, packing word gives the meaning of concentrating the votes in one place. Logically, would be done to opposition, right? Strategically, to let them win some seats while ensuring a large number for oneself. Similarly, cracking word gives the impression of breaking or diluting the voters. Logically, to weaken the opposition. So, just read these two things, and you can think of some more examples, or maybe use online resources to develop better understanding. Fourth statement says it can make the general elections predictable. Now, this is absolutely correct. And that is the whole purpose behind this manipulation, so that they can win certain areas by surety. So, only one of these is the correct statement. That is the last one here. Then, in the next question, it says the concept of curative petition was introduced by the Supreme Court in which of the following cases? Now, the correct answer here is Rupa Ashok Hurra versus Ashok Hurra. However, the other ones are also very popular, but not for this reason. Like Vineet Narayan versus Union of India, 1998. This is the landmark case which struck down what is called the single directive issued to the Central Bureau of Investigation, which stated that there had to be prior sanction of the designated authority to initiate investigations against senior officers of the government. The judgment also directed the union government to give statutory status to the Central Vigilance Commission. And that is why after this in 2003, CVC Act was also made. So it was to ensure CBI functions as a non-partisan agency, which appears to be a vision still not fulfilled. Read more on why CBI is still seen at times as an instrument in the hands of the government. Vineet Narayan, by the way, is a journalist, quite renowned in his time, and that picture there is Mr. Vineet Narayan on the screen. The third, MC Mehta versus Union of India, 1986. This is the very famous oleum gas leak case, where the court established the principle of absolute liability for hazardous industries, which meant that the company is strictly and fully liable to compensate the victims with absolutely no exceptions or defenses allowed. We have seen earlier the role of MC Mehta in some of the video discussions. I hope you have seen that. The fourth one says Menaka Gandhi versus Union of India, 1978. Now, this is the case we all know. It transformed the idea of Article 21 of our Constitution, that is the right to life and personal liberty, from a literal narrow right into an expansive shield against arbitrary state action. It read the due process of law in Article 21 by implicitly identifying the principles of natural justice for fair procedure and non arbitrariness, and held also that Article 14, 19, and 21 they form a golden triangle. I will make a separate video later to explain this relationship. The last question for this video: how many of the following items are not mentioned in the Constitution of India? Now, this is a decently straightforward idea. Bureaucracy as a term is not mentioned. Delimitation, of course, is mentioned in many places. There are various articles such as Article 327, Article 329, and also in the seventh schedule as a subject in the Union list. And transparency and accountability, these are also words which are not mentioned. Yes, responsibility is mentioned. We know collective responsibility is a concept. So 1, 3, and 4 are the correct answer because they are not mentioned in the Constitution. And these two persons are the first and the last of the ICS officers of India from India. Satyendranath Tagore, the elder brother of Rabindranath Tagore, joined in the year 1863 and was posted to Bombay Presidency. On the right is Mr. Nirmal Kumar Mukherjee, the last batch of ICS in 1944, who went on to become cabinet secretary and retired in 1980 and was also appointed as governor of Punjab. I wish you too get the opportunity to serve our nation and also humanity at large. For that, perhaps, is one of the greatest blessings and responsibilities one can be bestowed by the destiny. This series will now pause for some time, definitely to be resumed later. In the due course, I hope to make some short videos to explain the fundamental concepts and principles of polity. You continue to study well with focus and determination. May the forces of the universe be with you. Keep working hard. All the best.